All rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have a somewhat unusual posture in the case today, which Madam Clerk has discussed with you. We're going to start first with the focus order, which the appellants will address first.
Yes, Your Honor, thank you. May it please the Court, Glenn Burhans, Stearns Weaver Miller, on behalf of Walton County. As a matter of housekeeping, the appellants here intend to use 20 minutes combined on my portion of the focus order, which will be 10 minutes approximately, and then 10 minutes for Mr. Theriak on the merits of the appeal, reserving a total of 20 minutes for rebuttal.
Reserving 20 minutes to discuss the cross appeal and other matters?
Other matters with respect to the focus order as well. So
Right.
maybe we have to do 10 minutes their side, 10 minutes again on the focus order piece, and then...
Yeah, I think what we'll do is you want to do 20 minutes on the focus order or 10, you said?
I'd like to do, I think 10 is sufficient on the front end. For rebuttal, I'd like to reserve 10 minutes on the focus order. I want to make sure Mr. Theriak has 20 minutes for the merits.
I think that's a good plan. So what we'll do is you're going to have 10 minutes to discuss the focus order. The appellees will have 10 minutes to discuss the focus order. You can rebut on the focus order or bleed into the merits however you see fit. They can do the same. Then we'll do the second round of 20 minutes regarding the appeal and the cross appeal.
Thank you, Judge. Understood. It may come as no shock that Walton County answers both questions presented in the focus order in the affirmative. Yes, a justiciable controversy is created, and yes, a final appealable order obtains from such declaration within this court's jurisdiction, even if there is no named defendant. At the risk of getting preachy, I think it's important to set a little context for how we have to look at the statute, 163.035. And I'll just touch upon these points very quickly because I know you know them well and you've written opinions yourselves dealing with these very principles. So first and foremost, 163.035 must be construed as valid, must be construed as constitutional. When looking at the statute, we have to give meaning and effect to every word and every phrase. We can't read words out of existence. We can't render the statute a nullity. By the same token, we can't read words into the statute. So, for example, we can't add words saying the local government seeking a judicial declaration must name a property owner defendant in the case. Those words don't exist. And we submit, Your Honors, that is intentional by the legislature. And here's why. When you look at the structure of the plain text, first and foremost, it doesn't say anything about naming a defendant. In fact, the only text relating to a defendant is if and when a property owner provided notice decides to intervene within 45 days of receiving notice of the filing of the complaint.
What happens if a property owner never intervenes and you go through the entire case? Let's say Walton County did what they did, files the, we'll call it a complaint. No one intervenes. You go for the trial court. Trial court does what it does. Your client loses. And then you appeal. Who's the appellee?
I don't think you have to have an appellee at that point.
Really?
That's correct.
What do
because of
you
the nature of
define
the
as a
statute.
justiciable controversy? Like
Pardon me?
what would you define a justiciable controversy to be?
I think the justiciable controversy here is as between the adverse interest at play and whether or
So
not you have
amorphous
any...
interest, no one in particular, just the idea.
Your Honor, under this, because of the way the legislature drafted this statute, that's
I'm not
correct.
talking about how the
because-
legislature drafted. I'm talking about constitutional power of this court.
Understood. But whether or not you have a named defendant is really not required. What is required is the adversity of interest. And here there are clearly adverse interests based
Is
upon
that-
the inherent nature of customary use.
Is that how the Supreme Court has defined what are the scope of our power?
Well,
Or judicial power generally?
I can tell you that by way of analogy, when you look at the apportionment review process under Article 3, Section 16, don't quote me, I think that's it, that contemplates a situation where the review occurs whether or not anybody expresses an adverse position or anybody joins or files a
Sure,
brief.
but that is specifically spelled out in the Constitution. The people of the state of Florida can define judicial power any way it wants, and they can give the Supreme Court other powers if they choose. But with
I
respect
agree.
to the general judicial power, and our power is limited to final orders of trial courts, and trial courts have only judicial power, but you're saying that you don't need a defendant for there to be a controversy that would give rise to judicial power in the trial court.
No, I don't think you do. Now,
Well, let me ask
to
you
be
this.
clear,
Let me ask you this scenario then. Let's say just a general declaratory judgment action. I'm a citizen and I'm interested. I don't think there's a particular statute that is constitutional, so I file an action, a complaint for determination of constitutionality of a statute. I don't sue anyone. It's a complaint.
I think
People
that's-
can intervene if they want, but they don't have to. And you're saying that the court has the authority to answer my question about the constitutionality of a statute?
Well, not under the fact scenario that you present. I think
Why?
that would be seeking an improper advisory opinion, which is contrary to what you have here. The legislature has specified a mandatory requirement for a local government to exercise its powers to seek a judicial declaration. You have to file suit under the statute. You have to follow the notice procedure. There are two notice procedures. Now, as it relates to this case, Your Honor, the facts you present don't exist and cannot exist because, as a matter of fact, you have defendants that appeared in this case. Over 300 of them. Thousands of motions were filed. Over 300 depositions were taken. There was a clear adversity of interest that was not only presented as between the inherent nature of the customary use statute, the public's right of access and use, versus the property owner's right to exclude. That's always going to be in tension as adverse interest. But here, under the facts in this case, you actually had defendants who intervened. Now,
Can an intervener give jurisdiction that didn't exist previously? For instance, so if there's not a justiciable, and I'm sorry, I've always had trouble pronouncing it, but a justiciable controversy, if one doesn't exist at the inception of the suit, can an intervener create that controversy such that then the court suddenly has jurisdiction?
it's not the presence of the intervener that creates the controversy. It's the adversity of interest presented in the pleadings, in the
Well,
complaint.
but going back to my scenario, I mean, there's an adversity of interest. I mean, obviously the legislature thought that the statute was constitutional, and there's probably people out there who disagree with me that the statute is unconstitutional. But you're saying, in my scenario, my hypothetical, that that would not be permitted, but in this particular scenario, it is permitted.
Well,
What's the
certainly,
legal theory
and
that
here's why,
supports
Your
your
Honor,
position?
because in your hypothetical situation where we don't know what the statute actually says, we don't know whether it's a mandatory requirement for local government to bring an action with respect to seeking a judicial declaration in the first place. Here, the statute requires that to happen. In your hypothetical statute, we don't know what the text is, why it's required or not required, and what interests of an adverse nature are at play, if at all.
Does the Declaratory Judgment Act require that there be a defendant? Does it specify?
Well, we're not talking about the Declaratory Judgment Act. We're
I
talking
know,
about
but
an
I'm
actual-
talking about my scenario. So if there's a statute, the legislature authorizes declaratory judgments and suits to seek declaratory judgment, are you saying that as long as if the legislature, actually I'm not understanding your distinction. So under the DJA, even if it doesn't mention the requirement that there be a defendant, the Constitution requires that there be a defendant in a DJA. That's why you're resisting my hypothetical that it's bizarre in a DJA action for there to not be a defendant, because we all know that there needs to be people on both sides of the V.
I think
Your Honor,
I think the concern here is that I appreciate your comments about the legislature mandating Walton County to do this. I certainly sympathize with Walton County deciding that it had to go to court and declare that 1,200 property owners really don't own their property. But it appears that the statute is mandating that Walton County seek an advisory opinion. And is that constitutional? Or does it, in other words, does it confer judicial power on this court or on the lower court? How does the lower court have the authority under the Constitution to simply issue an advisory opinion? This is good, this is bad, this isn't good, this isn't bad. There's no adverse party. They appeared here because they were told their property rights were going to be stripped without compensation. But nobody trespassed on their property. Nobody was arrested for trespassing. There's no criminal action. There's no action involving the state versus a defendant. There's simply a court giving an advisory opinion. It happened to go against your client, but the concern here is, how is that valid either way? How did the trial court have the authority? Granted, the statute says so. How does the legislature have the authority to tell the trial court to issue advisory opinions?
Well, I'm not sure that I agree it's an advisory opinion per se. I will concede it's not of the type that has been specified under the Constitution, such as when the governor seeks an advisory opinion or an advisory opinion with respect to approving.
Let's try it this way. Do courts in general have the power to, can this court issue an advisory opinion? Unrelated to the constitutional provisions regarding the governor.
No,
We just decide we'd like to issue an advisory opinion that it's unfortunate that the Houston Astros lost in Game 7. We don't like that. We're going to issue an advisory opinion. Do we have that authority?
No, I don't think you do, Your Honor. But I think that's a different situation here. And again, I don't think we can divorce the inquiry from what the legislature specified in the clear text and requiring a local government to follow this process.
Nobody disagrees.
If we do that.
And again, my sympathies. Walton County was mandated to go seek an advisory opinion of whether or not it could strip these property owners of their property rights.
Well, Your Honor, I suggest if you were to find that the court lacked jurisdiction because there was no named defendant, ignoring the record below, which there were in fact defendants who intervened, I think that would be an impermissible advisory opinion.
I mean, is this an advisory opinion? Based on the plain language of the statute, we've got notice, you've got a specific proceeding. Keep using this term advisory opinion. Can you address that? I don't have a knee-jerk reaction that a decision under this provision is advisory.
Well, Your Honor, I think that's right. And I was trying to be responsive to the position where the other judges were coming from. But I think you're right. And where I started but didn't get to was that there are multiple layers of notice and opportunity for the affected property owners to appear. That they choose not to exercise that right doesn't mean you lack a justiciable controversy, doesn't mean you lack the adversity of interest. Now, in this case,
Well, let's try it this way. What if your client had gone to the court under this statute, none of these property owners appeared, they didn't have the wherewithal to hire a lawyer and spend, I assume, a pretty considerable sum defending their property rights. They don't show up. And the trial court says, yes, absolutely, based on what could be obit or dicta from the Supreme Court, the court now declares that every beachfront property owner, for that matter, in the state of Florida, has all their property rights stripped away, and anybody can access the beach through those properties, case closed.
Your
And
Honor,
then at that point, they don't appear, there's no appeal, you won. You won the advice, you won the opinion. Do they then lose those property rights? Assuming the customary use doctrine's valid, we're
They
going to
do,
discuss
and
that
I'll
later.
explain, but I would like to just respectfully push back on part of the situation you presented. It's not going to be opened up to everybody everywhere in the state. It's with respect to specifically noticed
It's every beachfront
parcels.
property owner in Walton County.
Only if they were noticed in the notice of intent
Okay.
and received notice of the lawsuit,
Yeah,
and then
again,
they decided not to intervene.
You file in circuit court. Yes, we want the court to declare that everybody in Walton County can walk through your property, put up an umbrella, camp out, whatever, on your property. Nobody shows up. No property owner has the money, the wherewithal, whatever. They don't show up. The court issues an order saying, yes, this is a proper application of the customary use doctrine. The time for notice of appeal expires. Do they then lose those property rights to exclude others from their property?
I believe so, and I'll explain. But what I'd like to note, very importantly, is that this is in the context of either keeping or adopting an ordinance.
Right.
So there will be that process that provides additional notice and constrictions on, it's not going to be a free-for-all. It's got to be with respect to the specified uses that were specified in the notice of intent and in the complaint, and it's got to be for the particular area of the beach
Well,
identified.
it could just
Now-
be the ordinance your client adopted in 2017, right?
Pardon?
In my hypothetical, should the property owners not appear, and essentially a default judgment, if you will, even though it's not precisely a judgment, the court says, yes, this is a proper use of the customary use doctrine. I hereby declare that every single beachfront property owner in Walton County has to allow people to walk through their property completely unfettered, put up a beachfront umbrella, put up a chair, use your property. The property owners don't show up. They've lost those rights to exclude others from the property.
Yes, if
That's
the county-
correct, isn't it, under your argument?
If the county has provided notice, as it should, 2 times and specified everything they're required to do in the notice and the complaint, then I think that's correct. And this is important.
Wait, are you saying it's res judicata against the property owners that don't appear in a suit that has 0 defendants in it? That's the position?
I think it would. If they failed to intervene as they were required to do under the statute, I think that's right. Now, keep in mind.
What is the point? So you can skip it sounds like it's a defendant class action, and you're saying that you can skip those rules as well, and just under statute they can.
Your Honor, it's not me, it's the Florida legislature. And consider
Well, but,
the impact
but the
of this.
legislature doesn't have the authority to have the courts do things that they don't have the authority to do. Right?
Well, fair enough. It's the county's
I mean,
position that they
separation
do
of powers,
have.
Article 2, Section 3.
I'm sorry, repeat.
Article 2, Section 3, the legislature can't have courts do things that are not judicial things, right?
Yes. However, the judiciary cannot supplant its judgment for the legislature. And the point I wanted to make earlier is that consider, to your point, Your Honor, people may not intervene because they don't want to spend the money or whatever. They may not intervene because they're fine with customary use. The point is we can't psychoanalyze those non-intervening
Well,
parties.
I know-
But what we can recognize is that by allowing people to not intervene, they could very easily avoid the effect of the judicial declaration, Whether they free ride on the intervening parties is really irrelevant, but what you risk is having a statute that can never be enforced and a judicial declaration that can easily be avoided because somebody decides, well, I'm just not going to intervene when I've received at least 2 forms of notice that my rights are at issue.
Well, we've asked you a lot of questions. I appreciate that. We're going to give the appellants, cross-appellees, 5 more minutes, Madam Clerk, and the other parties 5 more minutes. I would ask you to consider, while you're considering your rebuttal on the focus order, with my hypothetical, is that a taking? You could address it after the rebuttal. I think it'll be more in context then, but
Okay.
the property owners that don't show up, don't assert their rights, the circuit court rules in your favor and says that anybody can access their property without payment of just compensation by the county. Is that a taking?
Understood.
Thank you.
I'll think on that. Thank you.
Take the water off the counter.
Sure. Good afternoon, Your Honors. May it please the Court? My name is Joshua Pratt, and I, along with my colleagues Kent Safer and Mohammed Jazeel of Holtzman Vogel, along with our co-counsel from Matthew and Jones, represent the appellees cross-appellants in this matter. And I'm here today to briefly address the 2 jurisdiction-related questions that Your Honor has been discussing with my friend from the county. Now, as to the first question, we answer in the affirmative, but for different reasons. We respectfully submit that a customer use complaint under Section 163.035 can present a justiciable controversy, notwithstanding the absence of a named defendant, but only in the specific scenario presented here, where all 7 appellees intervened as defendants below and thereby waived any issue with respect to the trial court or the county's failure to name them as defendants in the customer use complaint. Now, Your Honors,
Can there be a waiver of lack of jurisdiction?
Yes, Your Honor.
A lack of subject matter jurisdiction, there can be a waiver.
No, Your Honor. As the Court is aware, subject matter jurisdiction is not a waivable issue. However, we believe this is more in line with a personal jurisdiction issue where it would be something that could be waived by
You don't agree
appellees.
then with the line of questioning that suggests that the statute must be read to require an advisory opinion?
Respectfully, Your Honor, I think, as a tenet of, constitutional and statutory interpretation, courts do presume that statutes can have a fair and constitutional application and reading. And I think here the Court can look at the statute and divine, just from its plain text, it says nowhere who must or must not be named as a defendant. And so I think there is a constitutional application.
That seems to cut against the validity of the statute.
Your Honor, respectfully not. The statute is more of a procedural mechanism by which to get this customer use issue in front of a court, but the statute shouldn't be presumed to jettison all principles of constitutional interpretation, to jettison the notion that rules of civil procedure apply. To the contrary, the legislature is presumed to know that courts apply, ordinary constitutional
I think I
rules.
understand your dilemma. Your dilemma is the argument you have on the customary use doctrine can't be reached if we determine the statute's invalid. Is that correct?
Your Honor, at this juncture, if the Court were to conclude that the statute could not have a constitutional application, then yes, the appeal would end. However,
Do you think this is that an opinion or a judgment under this statute is an advisory opinion?
Not as to these 7 appellees. The order that's on review by this Court is a partial summary judgment from the trial court below, where it resolved all of the county's claims. Really, they actually had 1 count for a declaratory judgment of customary use against these 7 appellees. And that's the judgment that's on review before this Court. And these appellees appeared in the trial court pursuant to their statutory ability to do so as intervener defendants. So there was an adversity of interest. And I would respectfully point the Court to the Florida Supreme Court's seminal decision from 1952, May v. Hawley. I know there that the Court was looking at the Declaratory Judgment Act under Chapter 86, but in doing so, it talked about principles that I think universally apply so that cases, when it's in a DEC action context, are within the constitutional power of the Court to decide actual controversies.
We'll start with my first question. Do you agree with the other side that you can have a lawsuit without a defendant and have that be a proper exercise of judicial or the proper invoking of judicial power?
No, Your Honor, I don't believe
Why not?
so. Because the business of courts is to decide actual controversies between parties with perhaps the narrow exception, I will concede of an in rem action where it's actually against a piece of property, you're adjudicating title thereto or some ownership interest. But here, clearly, we do not have an in rem action. It would have to be something that's either quasi in rem, because it mixes both personal interests and property, or a personal jurisdiction matter. But
Okay.
we do believe that that's a waivable issue as to personal jurisdiction. But I suppose the court could
Right,
also.
but this is not, so your answer to my first question is not a personal jurisdiction question. That is firmly a subject matter jurisdiction, or just the pure exercise of constitutional power of court. Take it to the next step. So we can't have and I tend to agree with you that it seems a bit odd that there would be a complaint without a defendant and have that be a proper invoking of judicial power. Let's say in this instance, so then can an intervener create that jurisdiction that didn't exist before? So the complaint's filed, it's an improper invoking of the constitutional power or the power of the court. And then an intervener files a motion, wants to intervene. And then the court grants that motion. What is the authority of the court to grant that motion, and is that enough to then create jurisdiction? Can a court create its own jurisdiction by procedural order?
Sure. And the point is well taken, Your Honor, but I think the procedural nature of it perhaps is another way to look at it that may shed some light on the matter. There is something called procedural jurisdiction, which is also case jurisdiction or continuing jurisdiction, where courts, to your point, do not have the authority to act because maybe there's a procedural defect. In fact, in the Anthony Irish case from the 5th DCA, they talk about one of those being an improper pleading. And here, I think the court could view the county's complaint as just an improper pleading. It failed to do that minimum of naming defendants, which it should have because it's not an in rem action. However, the 4th District and the 6th District have acknowledged that procedural jurisdiction is waivable. I know there's a conflict in the DCAs. The 2nd District has said it's not. And of my brief review, I'm not sure that the 1st DCA has weighed in.
Well, let me ask you my hypothetical that I asked the appellants, which is, assume none of the beachfront property owners of Walton County appeared here. County filed the notice of intent to declare every beachfront property owner in Walton County subject to free access by non-property owners. None of the property owners show up either because of lack of resources or they just didn't have the wherewithal to appear. Court enters an order against every property owner in the county of Walton that your property now is less valuable. You now hold your property subject to access by anybody that wants to walk through it, set up a umbrella, camp out, whatever. Did they lose those property rights because they didn't appear?
No, Your Honor. I do not believe that they lost them. I think that order would be voidable as to them because they were not properly made defendants, and in that decree.
But no, remember, under the statute, nobody has to name a defendant. The county just did what the county did, and I don't think there's any argument that they didn't comply with the statute, right?
No, Your Honor. They did comply with the
with the
procedural
statute.
license.
They filed their notice of intent to declare every beachfront property owner in Walton County subject to these access demands. And there are a lot of reasons why people may not exercise their right to appear, if that's the way you could put it. Case is closed. Do they lose those property rights?
No, Your Honor. I do believe still in that scenario that the statute did not displace the irreducible constitutional minimums, that there had to be a controversy. And in order to be there to be a controversy, although the naming of the defendant is kind of the way to ensure adverse interests are properly before the court, you actually have to have those adverse interests under May v. Hawley brought before the court.
But here, did the complaint, remind me, did it name every single, because according to your cross-appeal brief, it affects almost 1,200 properties, is that correct?
The complaint does. The case has since narrowed from that, but it is named.
To how many now? Just the 7?
There's 6 pages of specific properties listed in the complaint, right?
Correct, Your Honor. So, on review, the complaint captures all of those. But here we do have the 7 appellees who did intervene. They did defend pursuant to the statute.
So the beachfront property owners that did not intervene, if the trial court opinion had been in the reverse, would they lose their rights under their property rights to block access to their property?
They would not, Your Honor, because they were never properly brought before the court so that the court's jurisdiction could be applied against them in
How
any
are they
degree.
not properly brought before the court under this statute? Nobody's arguing that Walton County didn't comply with the statute. Walton
Yes, Your Honor.
County listed the properties that it was going to declare hereby and forever in perpetuity. People could access through that property, and Walton County was not going to provide any compensation. There's no procedural failure on the part of Walton County or the court, right?
No, Your Honor, not as to the niceties of the statute, but the statute does not displace the requirement that there still be an adversity of interest that's being adjudicated by the trial
That seems to
court.
be a circular way of conceding that the statute's invalid.
No, Your Honor.
Logically, your point seems to be, and again, I think I understand your dilemma. The point seems to be that, no, it's not an invalid statute, but if nobody appears, their property rights can't be taken away from them because they just didn't show up.
Yes, Your Honor, where no
That's
one.
typically not how a default judgment works.
It's not, but I would say just taking a step back just to try to get it another way.
Okay.
The statute sets this procedural mechanism and conceivably does provide for this alternate notice process. But I think notice.
But every property owner got notice, right? There's no argument here that there was a failure of notice, is there?
That issue is not presented on this appeal, no, Your Honor. But the statute, conceding, even assuming that the county complies with that, there's still this constitutional defect of failure to bring the adverse interest before the court. And I think I would point the court to the Florida Supreme Court's decision in Irvin v. Taylor from 1953. There was a deck action complaint that was brought against the statute. There was no named defendant. There were some interveners, an attorney general and state attorney, and eventually a decree was entered, but with no named defendant. And the issue seemed to be for the Florida Supreme Court on appeal, talking about the lack of adversity and the lack of a justiciable controversy. The court focused more on no one being named in the decree with an adverse interest. It seemed not to focus so much on the failure to name someone in the petition. And I would submit that that is consistent with maybe Hawley, where you look at the different requirements there for a deck action to be within the constitutional ambit and authority of the court to decide a controversy. You need a justiciable, or rather an actual controversy. You need there to be parties who have adverse interests, and then those adverse interests need to be before the court. And we would submit here that even though there was this procedural defect, that the adverse interests of these 7 were before the court and properly justiciated. But as to the world of others, it was not.
My question to the other side, to Mr. Burhands, was take the DJA for a moment. Could the DJA be read? Is there a requirement in the Declaratory Judgment Act that there be a defendant when you bring a declaratory judgment action?
Not necessarily that I'm aware in Chapter 86, but
Right.
there is a provision that says you cannot prejudice the rights of non-parties. And so I think the legislature in that way protects someone from the possibility that someone might.
Well, but just let's run with this for a second. So I file my hypothetical lawsuit. If you want to call it that, in re, Florida statute section, just fill in the blank, some statute. I'm filing it under the DJA, and I am interested. I want a determination from the trial court as to whether this statute is constitutional. And it's in re, it's a complaint. I file this petition, and I set out the basis why I think it's unconstitutional. I don't name a defendant. I don't serve anyone. But I do advertise, like, hey, everyone, I have filed this lawsuit. And if you want to get involved and say your piece, come in and intervene. Let's say, and then I'm assuming, based on your prior answer, that suit by itself is problematic.
Yes, Your Honor,
Okay.
because
What if then someone moves to intervene and is allowed to intervene as a defendant? Is that now fixed? Is that okay?
I don't think so. Well, I guess maybe taking a step back, I know that the case in this hypothetical is pleaded as an in re action, and so I assume that to mean that it's presumed to be in rem. And so I think in rem cases are that narrow band where
I didn't
even this
presume
court
that.
and
There's no properties that have been seized. There's no writs that have been issued on these properties. I
Correct.
did not read the in re as to be in rem. I read the caption to be, hey, the statute makes us file this thing, we're going to call it what the legislature requires us to call it, and, oh, we don't know who to put as a V on the other side of the V, so we'll just call it in rem.
Sure, and so, yes, admittedly, the in rem actions do require a named defendant, and this court even says that in the In Re 73 Engel-related cases from 2018. But if it's not in rem, then it begs the question, what is it? If it's in personam or quasi-in rem, you do need a named defendant, and we would just fall back to the argument that we submitted earlier that even if this court looks at that as a procedural jurisdictional issue, that there wasn't a technicality of a named defendant, the defendant with the adverse interest is actually entered, and it's against their properties. Because it's kind of quasi-in rem, it's kind of a blended action against both them and their property itself.
So your position is that an intervener can come in and create subject matter jurisdiction or properly or fix the improper invocation of judicial power procedurally, I guess, by
just with the caveat, Your Honor, that in our view, this is not a subject matter jurisdiction defect, that it's a waivable either personal jurisdiction or procedural jurisdiction defect. But if this court viewed it as subject matter jurisdiction, then that would be correct. It could not be waived.
Well, it seems both parties agree that the statute is valid, at least in the cases applied to these parties. So just to keep the argument organized, I'm going to ask you to present your initial argument on the cross appeal. We're going to do the cross appeal first. Excuse me?
Ask more about the jurisdiction?
All right, go ahead.
Looking at the order itself, so put aside, I guess, any concerns about the judicial power, any of our understanding of what judicial power actually is, looking at the order itself that's on review. Whose legal relationship has changed and how has it changed? The legal relationship between two parties, right, which is the definition of a judgment, changes, alters the legal relationship or the rights between two parties forever. So you got Walton County, and I guess you have the 7 appellees. Mm-hmm. How has their legal relationship changed based on the order? What does the order do to alter their legal relationship?
Sure, Your Honor. I think at its core, the practical effect is customary use can no longer be sought by the county against our clients or their properties, or rather all appellees and their properties.
What does that look like to seek customary use? Because I'm looking at the ordinance from 2017, and it just declares you can't interfere with someone, any property owner cannot interfere with someone walking across the, I mean, I'm summarizing, but basically no one can impede a member of the public's access to come on the sandy beach and build a sandcastle or put out a chair, and you'll be subject to $500, up to $500 a day as a civil fine. You're saying that this order that's on review is basically a get out of jail free card? They hold that, and if a cop comes up and tries to cite them, I've got this order that says that it's not customary use on my property. Is that what that order does?
Not quite, and not to seem to be evading. I know my co-counsel, Mr. Safert, will address more of the particulars of the order and the issues of abandonment that the trial court ruled on with respect to the 1978 resolution. But I think as to the relationship between the parties, Walton County in the case here actually has abandoned, and it cannot seek customary use against these appellees parcels. And so as to them,
seeking customary use is this term of art which doesn't actually exist in this record at all. It started out as an ordinance passed in 2017 that didn't seek customary use. It just declared, like, hey, if you cannot interfere with someone coming on your property to use the beach between the mean high water line and I guess what the hip or the elbow or whatever, the dunes and whatever else. So in that portion where people like to, pitch their tent and build sandcastles. That's what the ordinance says. And it provides a penalty if you do that. That's not seeking customary use. That's declaring a policy precluding people from doing certain things, maybe based on customary use, but that's not, the ordinance doesn't seek customary use against anyone in particular's property.
Sure, Your Honor.
And I also don't see, so this ordinance is still on the books. I looked it up. It's still there. And I don't see how this statute makes it not exist. And so I still don't understand the effect of this order. And my point in asking this question is, You can say all you want about, well, there's an adverse interest. I mean, there would be adverse interest if I brought up a question of whether the abortion law was constitutional. That would be adverse. But it doesn't necessarily invoke the judicial power of a court just because there's adversity on an issue. And ultimately, the dispute has to be resolved in some way conclusively, which is going to alter the relationship or the rights between two parties in the case. So my question comes back to this order that's on review. How does it do anything that would constitute properly the title of final order?
Sure, Your Honor. So just to step back and provide maybe a little clarification. So yes, the county did pass a customary use ordinance, but Chapter 163.035 actually voided that ordinance, and so
It
that's
said void? Because I looked at the statute, it didn't.
That's our reading of the statute, Your Honor, that it made it no longer effective, even though it may still be technically on the books. And what the county has done is kind of sought through this procedural mechanism a means to affirm, maybe instead of seek to establish, they're seeking to affirm what they believe is pre-existing customary use on the parcels, such that perhaps maybe one day they can enact an ordinance pursuant to the statute. Because the statute, as a condition precedent, requires a judicial declaration of customary use on a parcel before any type of ordinance trying to regulate that would occur. And that's just, in effect, kind of what the statute did. But as to your question to the particular order here, I guess at the end of the day, the effect is there is no customary use on Applebee's parcels. And so as to the county's claims to the contrary, those just are ineffectual.
How is this not asking a court to exercise quasi-legislative power as opposed to judicial power? I mean, it seems like it's putting it. Couldn't an agency do this, play the same role in this case? Like, couldn't the legislature say, county, you cannot have a customary use ordinance until you get approval from DEP or pick an agency? And, and then the agency has to, have hearings and acquire data and then issue some sort of administrative order declaring one way or the other, like a license. You may or may not, exercise customary use in your county. Could that not happen?
I don't believe so, Your Honor. That's more akin to kind of an exhaustion, maybe requirement before getting to court. But here what we have is...
No, my question is not about exhaustion. My question is, could not the legislature, would that not be an appropriate use of legislative power or a delegation in some way, as long as there's intelligible principles and specific criteria that they're supposed to follow? Couldn't an agency affirm, issue an order, a license even, affirming the customary use application in Walton County?
Respectfully not, Your Honor, because in that circumstance, you would be having a non-judicial officer taking away property rights, constitutional rights from appellees.
How?
And because saying that customary use exists actually then takes away or eviscerates their bundle of rights and ability to exclude the right to be free from unconstitutional takings.
How would that be the case? An administrative order that just says, okay, there's customary use, which then just authorizes the county to adopt an ordinance. How is that taking away anyone's rights? That's just authorizing an ordinance.
Your Honor, it seems to be it's just shifting from the county to another agency, something that's never properly within agency jurisdiction. It should be something that is reserved to the courts within the ambit of the judicial power to decide rights to property or rights not to property. And when someone's constitutional rights are implicated, as here with appellees, the court should not perhaps envision a scenario where maybe it would have been better to have an agency do it. It's the role of the courts in our view.
Would you like to present your arguments on the cross appeal?
Yes, Your Honor. Thank you.
And the reason I'm doing that first is if the court rules in favor of the appellees on the cross appeal, then it moots the appellant's argument on the direct appeal.
Great. Thank you, Your Honor. May it please the court. Kent Seyfried with Holtzman Vogel.
I'm sorry. To be fair, you wanted to present any rebuttal argument on the validity of the ordinance? I didn't hear an argument that they think the ordinance is invalid, but if you want to present rebuttal and use your time for that, that's fine.
No, you're absolutely right, Your Honor. We can proceed with the
All
cross
right.
appeals.
Thank you. Sorry about that.
Again, thank you, Your Honor. May it please the court, again, Kent Safrit, on behalf of appellees across appellants with respect to our co-counsel as well. With respect to the cross appeal, Your Honor, to borrow from Justice Scalia's analogy in the Stop the Beach renourishment case, we cannot begin discussing how much wood a woodchuck can chuck until we first determine if a woodchuck can actually chuck wood. And here the threshold issue with this court is whether or not the Florida Supreme Court's discussion of customary use in its 1974 case of the City of Daytona Beach versus Tonorama was dicta, or was it substantive law that the Florida Supreme Court created? And second, if the discussion was not dicta, then does the judicially created doctrine of customary use, which authorizes the general public to physically invade private property, thereby eliminating the landowner's fundamental and established right to exclude, violate the United States Constitution as either a taking or a due process violation in light of the 3 U.S. Supreme Court cases decided after 1974? That is the Kaiser Aetna case in 79, Stop the Beach renourishment in 2010, and Cedar Point recently in 2021.
So wait, so cross appellant's position is don't rule that the statute is unconstitutional for the reason that we suggested in the order. Rule that it's unconstitutional for the reasons that we want to argue. Is that the position?
Not exactly our position, Your Honor.
Why does it matter what the Supreme Court said about customary use? We have a statute in place that requires a court to make some sort of affirmation or determination out of the blue in the ether as to whether there's customary use generally in Walton County.
That's correct, Your Honor. And to the extent, a little bit of history here, when the county adopted their ordinance in 2016, they adjudicated property rights from the legislative dais. They don't have the authority to do that. The exclusive jurisdiction to determine property rights is vested in trial courts in the state of Florida. Only a trial court can determine property rights.
How did they adjudicate property rights?
They determined that customary use existed. They determined that the public.
Who cares? Why does it matter that Walton County said in a precatory statement that we recognize customary use in Walton County?
It matters because after they did that, the sheriff would not enforce trespass laws over there, and public members were on that private beach.
Well, that's a problem with the sheriff.
Well, it is. But again, the resolution or the ordinance they passed, we say, constitutes a taking of private property for that year that it was in effect. So again, they adjudicated property rights, and they didn't have the legal authority to do it, and it constituted the taking of private property during that.
Did you file an inverse condemnation act?
We filed an action in federal court, Your Honor, absolutely.
That's pending?
I
don't want to get into matters beyond the record, but.
Yeah, so we attempted that. Ultimately, the legislature passed 163 to fix this problem of.
Which, do you agree that preempts the ordinance?
Absolutely, Your Honor. And
so your agreement on that issue too, apparently.
Yeah, and so the statute says you as a county commission across the state can't adjudicate these property rights. You got to go to a court to do it. Now, and it set up procedural hurdles for the counties to go to court to have the courts adjudicate property rights. And you heard some of the jurisdictional arguments on that a little bit earlier. And so it put the separation of powers issue back where it was supposed to be. Legislatures can't determine property rights. They can't adjudicate them. Courts can. And so legislatures can't say the use has been ancient, it's been free from dispute, it's been uninterrupted. They can't do that. A court has to do that based on evidence. And so that's what 163 does, is it says you got to go and have a court do this. Now, the county in this case should have named every one of these 1,194 properties as an individual defendant. They failed to do that. That's created issues, obviously, in this case. Rather than sit back and not do anything, a lot of my clients intervened to defend their rights because of this new statute. And so they're here arguing that this whole thing is unconstitutional customary use doctrine, so we shouldn't even be here. But the statute itself is not.
Couldn't they have just sued to challenge the validity or the constitutionality of the ordinance?
No, the constitutional or the ordinance, Chapter 163, is a blessing to the landowners.
Yeah, we told you that in North Shore. You came and tried to do that with us, and we said it's not right.
That's right, because that landowner had not intervened in the case. These 7 have intervened, asserted these defenses.
So now you're back having gone through the process.
Exactly. And so the statute, 163, actually benefits the landowners in the sense that it creates a procedural bar from local governments declaring from the dais via an ordinance and taking their private property rights. It protects their
But the
property
ordinance
rights.
doesn't declare property rights.
It adjudicates them, it doesn't.
No, all it says is that you cannot impede, you cannot prevent someone from using the beach that may happen to be on your property. But generally speaking, it's not specific to a particular property owner. It just says no one can impede the use of someone else, a member of the public, of the sandy beach part to build sandcastles and put up umbrellas.
Yeah, well, we disagree with that, Your Honor, because I think when the legislature.
That's what the ordinance says.
Just as the Florida legislature said, all of the beach from the dune line to the mean high water line is subject to public use. Now, if the legislature passed a bill saying that, that's a taking. They're declaring property rights, who have the ability to use that property. That's an adjudication of rights based on whatever theory they want. And in this case, the theory is customary use. And that's where we're getting into customary use being unconstitutional, because it's a doctrine that was created by the 1974 Florida Supreme Court. And the primary issue, as I was talking about earlier, is this dicta. And I believe you, Judge Thomas, said earlier it might be obiter dictum. And that's exactly what it is in this case, because the facts in Tonorama are expressly clear that the only dispute was the 230 square foot foundation of a tower.
Yeah, we know about the case. Let me ask you this, that assume we agree with you that customary use doesn't exist. It doesn't exist under Supreme Court precedent, and if it did, it would be unconstitutional anyway. Where are we in this case?
The case is over,
Why?
because customary use is unconstitutional, so the county cannot proceed, and a lower court cannot issue any type of judgment
But the
declaring
lower court
customary
didn't
use.
rule on the constitutionality. Well, it ruled that it was that customary use could be applied,
Oh, that customary use could be applied.
but it was not going to allow it in this case, correct? It rejected your arguments that the language in this 1974 case was dicta. It just didn't go there. It didn't dismiss the case. It granted your client summary judgment on the merits of a customary use argument, correct?
Correct.
Okay, but if we hold there is no such thing as a customary use doctrine.
Right. If there's no.
If we rule in your favor on that point, where is this order?
If there is no such thing as customary use because it's unconstitutional, then the trial court has no jurisdiction to enter any kind of order with respect to any type of customary use.
Which leads us back, sorry to keep doing this, but then leads us back to where we started, which is this appeal would be dismissed.
No, I don't think it would be dismissed, Your Honor. If you find customary use is unconstitutional, it would be remanded to the trial court. The trial court would dismiss the case for failure to state a cause of action because there is no such thing as customary use.
What does unconstitutional mean to you? When you keep saying customary use is unconstitutional, so my understanding of unconstitutional goes back to Marbury versus Madison. So you have a superior text and a junior text, or a superior law and a junior law, and there's a conflict between the two laws, and then the superior law is going to control, and that's what we call unconstitutional. What is the superior text and what is the junior text?
Yeah. In this case, customary use is unconstitutional for violation of the Fifth Amendment.
And I'm not asking why.
Okay.
So start with the junior text. What is the junior law that you're claiming conflicts with superior law?
The 1974 Florida Supreme Court ruling that judicially establishes customary use.
So you are now equating a Supreme Court decision with the law of the state of Florida.
Correct.
Okay, I thought the legislature exercised lawmaking power in the state of Florida.
Well, they do, but courts under some common law theories have, a declared common law, and they have those powers. Whether they should or they shouldn't, they've done that in the past.
Well, wasn't the customary use actually a common law principle applied to a specific dispute between two landowners?
It's actually
in the context of an easement or a prescriptive easement or something like that?
Actually, customary use is a local law in England.
Well, I know. Yeah, I read the brief. It was
England
very
is a
helpful.
local law,
Yeah.
so it can only apply to certain people in certain places at certain times. Florida Supreme Court in 1974 created this brand new doctrine not out of thin air, but said customary use in Florida applies to the public at large, and it applies to your beach.
Well,
And-
really, you just quoted the prior case, which had to do with a beachgoer that got hit by a car on the beach in Duval County.
Yeah, and that.
And then they applied it, I guess they tried to apply it in the Tony Roma case, actually to say, actually there wasn't an adverse use between what the person was wanting to build the tower and what the public was already using the beach for. So I don't know really what we're supposed to glean from either Tony Roma or the prior Supreme Court cases talking about customary use, other than it's just a concept that was mentioned, quoted at length a couple times by the Supreme Court and applied very narrowly in one case. And I actually don't even understand what the application was, why they even mentioned it in the earlier case with the beachgoer who got hit by a car.
Right. And in that case, Your Honor, it's the White case, and that had absolutely zero to do with private property in that case. That case dealt with the use of the publicly owned beach from the mean high water line to the actual water line, which is owned by the state, cars driving on it, and beachgoers using it. Somebody got ran over. They sued negligence. Had nothing to do with private property. So it had nothing to do with customary use or anything else. And so there, the Florida Supreme Court said the beachgoers laying out in the sun have a superior right to public members driving their cars on the beach. That was it. It had nothing to do with superior rights versus privately owned property versus publicly owned property. So that case just had some language in it.
And in the Tony Roma case, you had a dispute between two adjoining property owners. You had a guy that had already built the tower who didn't like the fact that this other guy was building a tower that was going to compete with him. And so he came up with a legal theory as to how he could trash that.
That's correct. And the legal theory of the doctrine of custom, Your Honor, is the theory is to make public or privately owned property available to the public without the payment of compensation. And it's a attempt through judicial fiat to do that without the taking of compensation. And I believe this court, in the underlying Daytona Beach Tonorama case, expressed just that to the Florida Supreme Court. And this court said, we now expressly reject the contention embodied in the foregoing excerpts from the appellate's brief, being customary use. Were we to accept such notions, it would amount to expropriation of private property without compensation by sheer judicial fiat. Our initial decision herein was and is in no way influenced by the appellee's notion that the need to preserve beaches for public recreation in any way authorizes the taking of such beaches from their lawful owners.
So what we have here is the Supreme Court in 1974 decided that case not on principles of customary use, but on whether there was a prescriptive easement, as I recall, and said there was not a prescriptive easement. So its discussion of customary use was not in any way integral to the ruling of the court. And out of that, in 2017 or 16 or 18, 2017, Walton County drafts passes an ordinance and says every single beachfront property owner in this county is stripped of their right to exclude trespassers from their property. All based on those statements regarding customary use in the Tony Roma case.
That's exactly right, Your Honor.
So if we find there's no such thing as customary use, that it doesn't exist, that was dicta, where are we with this statute? It means this statute addresses an issue that does not exist.
The statute would then become moot because this court it would become moot in in this jurisdiction, the first DCA. It's
a statute addressed to the county mandating that they seek an advisory opinion regarding a doctrine that does not exist. Well, is that a fair reading of the situation here?
Well, that's what this court has to decide, whether customary use exists or not. The statute was drafted as a result of local governments adopting these ordinances to prevent them from doing so without due process.
I assume Walton County wasn't the first or the only one.
Correct.
I don't know if that's part of the record.
Correct. And so the statute would then become a nullity. If there's no such thing as customary use, no local government would use 163.035 anymore because a court has said customary use doesn't exist. The legislature.
Wait. Go ahead.
Do we really have to get there? Because to me, let's get back to this case and these facts. And I just, as we were in this line of questioning, look back at the order again that we're here on. I don't see, if we were to find that customary use was unconstitutional. I do not find anything in that order that requires reversal. Basically, it would be the same decision, call it, whatever you want, but the judge didn't make a decision on constitutionality and said there was regardless, there was no customary use before the 1978, and after, I can tell you there's not enough time to qualify for ancient. So I don't see any reason for us to have to reverse or send anything back to the trial court if we were to say that customary use is unconstitutional. Do you agree with that?
Well, in this case, if you say customary use is unconstitutional, because the judge below said, my hands are tied, I can't get
Right,
to the
but
constitutional.
essentially the result would be the same.
The result would be the same. There would be no customary use on these 7 properties.
Right.
That's correct.
Okay.
Yes, Your Honor. But for 2 different reasons.
Right.
If it's unconstitutional, it would mean that
Or it doesn't exist.
it doesn't exist.
Your
Exactly.
first argument is it's dicta.
Right.
That's your argument here in your cross-appeal brief, that it's dicta.
That's correct.
And there certainly seems to be a strong argument for that when the case was decided on a prescriptive easement principle.
But the legislature has said it exists.
No,
So I
but-
don't understand why we care whether the Supreme Court said it in dicta or described it in some other way, someone wrote a book about it. The legislature says it exists. It's in the statute, which you tell us, because everyone agrees, apparently, no one wants to take up the issue about jurisdiction. Everyone agrees that we have to presume that the statute is constitutional. But then you want us to say, well, but then this is a moot statute because the Supreme Court said something in dicta.
The statute does not create a cause of action or say customary use is or isn't a thing. The statute only says counties and local governments, you cannot adopt an ordinance to adjudicate customary use rights. You got to go to court to do it under the Tonorama decision. That's all the statute
But no, the
does.
statute does not mention Tony Roma. It says
Well, it uses the elements.
it
Ancient,
doesn't
free from
matter. They
dispute.
could have made any elements up that they wanted, but the legislature said there has to be these things that the court has to determine, affirm that it exists before you, county, can adopt this ordinance to do whatever with respect to customary use. So it's a condition precedent. The legislature's put the courts in a position of I guess giving a permission slip, check our homework kind of thing, before we can go forward and do anything else.
That's absolutely correct. It's a condition precedent is all the statute is, because the legislature did not adopt or create or codify the doctrine of customary use. In fact, in section 2.01 that was adopted, I believe, in 1867, it says no laws of a local nature are being adopted from England. This is undoubtedly a local law, customary use is. So customary use could have never been a law in this state, background principle or otherwise,
Until the
since
legislature
1947.
adopted the statute.
I'm sorry?
Until the legislature adopted the statute.
Well, in that, they didn't create a customary use. In it, they just put up a procedural condition precedent that local governments have to go to court to adjudicate property rights versus adjudicating them themselves as a legislative
But
body.
you still take the position that this is not an advisory opinion. That the
Not in this case where the 7 people, 7 interveners intervened to defend their property rights.
Can I, do you
Judge
mind,
Thomas? No,
Chief?
please.
A clarifier, when you agree that the statute is valid, I'd like a distinction from you, please, and I think it may help the panel. When you say, I think the statute is valid, that you think it's a valid procedural avenue, but you think it's maybe, you do have a problem with it, or it's invalid from a constitutional perspective, that there's a separation of powers argument with the legislature writing into this statute that there is customary use.
That's correct. If you read section 163.05 as saying customary use is a thing, and the legislature creating a cause of action for that, the legislature has just violated the Fifth Amendment and created a taking under all of the case law that we mentioned. So if you read 163 as just a procedural statute, it's not unconstitutional, it doesn't create an unconstitutional taking. But if the legislature says customary use can exist on your property and is a thing, then the legislature, and not the Florida Supreme Court in 74, has created a taking of your right to exclude under the customary use doctrine. That's why customary use cannot be a thing whether the legislature says it or the court says it,
You're
because it
down
violates
to
the Fifth
3
Amendment.
minutes. Perhaps I should have allocated an hour apiece, but I'm not going to. So do you want to save that time in case you want any rebuttal on
Yeah,
the merits?
I'll reserve the rest. Thank you, Your Honor.
Thank you.
May it please the court, I'm David Theriak, I represent Walton County. Good afternoon. In regards to the cross appeal, it's the county's position that it's hypothetical upon hypothetical, it's premature. It's very close to the North Shore. What they are assuming is that if this court were to reverse Judge Green, remand the case back, for their arguments to hold, they have to assume that Judge Green is going to determine that the facts establish that customary use exists on their property, and they have to assume that the county will adopt a new ordinance regulating customary use. So we respectfully submit that as it pertains to the cross appeal, it's simply premature and should not be addressed by this court. The issues that should be addressed are whether Judge Green correctly determined that the county had the legal authority to abandon the public's right for customary use. And the argument about dicta and the argument about what did the Supreme Court say in Tonorama, I think is almost irrelevant because the legislature acted, and the legislature adopted 163035. And contrary to what opposing counsel argues, it's not a procedural statute. In fact, the staff report specifically stated that it is a newly created cause of action and is similar to a declaratory judgment. In a close reading of the statute, it states a governmental entity that seeks to affirm the existence of a recreational customary use on private property must follow the procedures set forth in this subsection. And then it states the court must determine whether the evidence presented demonstrates that the recreational customary use for the use or uses identified in the notice of intent have been ancient, reasonable, without interruption, and free from dispute. The legislature set forth the test to establish customary use. To the extent that somebody wants to challenge what the legislature did in this statute, that's not before this court. There's a process to challenge a statute. It wasn't followed here. The statute is presumed to be constitutional. So this statute is what we're traveling under. And that's what Judge Green, in looking at the evidence, has to determine, is if we meet each of those four prongs. That determination has not been made in the affirmative on these property owners. The only determination that's been made is that there was an interruption in 1978 when the county adopted a resolution. We would submit that the resolution cannot legally constitute abandonment of the public's right.
Let me back up just for a second. I appreciate your framing the argument. Is it your position then that if we assume the statute is valid and that they can't challenge the constitutionality of customary use, assuming the legislature created that doctrine?
It's the county's position that if they're going to challenge the constitutionality of 163035, there's a process to do so which they have not followed.
Well, they argued it below.
They argued below, but they didn't follow the statutory process, which includes notifying the state attorney of a challenge to a state statute. There's no dispute that they have not sought the proper invalidation of a state statute. And while they're raising constitutionality issues, I would also submit that typically as a doctrine of appellate courts that you don't reach constitutional questions if there's no need to reach a constitutional question. And here we submit that the constitutional questions are premature. We submit that really that all that's involved is, was Judge Green correct when he determined that the county abandoned the public's right to customary use?
And what effect does that, I'll ask you the same question I asked the the other side. What effect does the order on review have on anyone as a legal matter? Whose rights have been altered or adjusted,
I
or
guess,
extinguished, or what legal relationship has been changed?
I guess if Judge Tannenbaum doesn't object, I would clarify the question to say, if we affirm, what happens to these property owners?
If the court affirms Judge Green's ruling, his final judgment, then these 7 property owners are free from any claim of customary use on their property.
So the sheriff will have to arrest trespassers just on those 7 properties.
Actually, we don't have authority over what the sheriff does. So
I understand that,
I
but.
can't say whether.
But
the
that would be
sheriff-
trespassing, correct?
Up to the sheriff.
No, it's not. If somebody accesses property without permission, if there's no customary use, then these 7 property owners have a right to have the trespass laws enforced, correct?
Yes, they do.
I mean, whether a prosecutor declines to prosecute or not is a different question. But all other property owners, if we affirm, how are they affected by this order?
They're not, because this order only pertains to the 7 property owners.
So are they stripped of their property rights to exclude trespassers?
No, because there has not been a final decision on those other property owners, Your Honor.
Well, as to these 7, what does it mean? I mean, I haven't gotten really an answer yet. A claim of customary use, it keeps being used as if it's this thing. What does that look like? A claim of customary use?
Let me back up when I answer that question, Your Honor. Initially, the county adopted an ordinance.
Yeah.
And
Read
the
it.
legislature invalidated that ordinance. In fact, the 11th
How
Circuit.
did it invalidate that ordinance?
They stated any ordinance adopted after a certain date is invalid. Ours was not adopted prior to that date, and therefore they invalidated our ordinance. In fact, the 11th Circuit Court of Appeals also entered an order in a federal case stating that our customary use ordinance was invalid as a result of 163.035.
Was that in the session law that didn't make its way into the statute, or is it somewhere else? Or are you talking about subsection 4 of the statute?
Pull it, Your Honor. Subsection 4.
And you're relying on subsections where it says may not adopt or keep in effect an ordinance? Is that what you're relying on, to say that it's void?
Yes.
Okay.
As well as the representations that the county has made in federal court agreeing with folks opposing our ordinance that it was invalidated by the legislature through adopting 163.035.
Well, what does it mean to,
And that's the next step.
so you do accept the idea of preemption? So if Florida statute overrides a local statute?
Yes.
Okay. Is there not a trespass law on the books?
Yes.
In Florida statutes? So how is the 2017 ordinance in effect? If it says, so if it is trespass to go on someone's property,
Well,
and the ordinance says you will be fined $500 a day, up to $500 a day, if you impede someone's access to your property on the sandy beach. How is that not preempted?
because the doctrine of customary use that was accepted by the Florida Supreme Court, accepted by the Fifth and Trapanier, accepted by 2 or 3 federal court decisions, accepted by Oregon, holds that the property owner never had the right to exclude in their bundle of rights. So when a local government adopts a customary use ordinance protecting the
Does
public's...
the Supreme Court have the authority to do that by fiat? To extinguish rights by just a declaration and an opinion?
It has to be based upon background principles of state property law. And we read Tonorama to have established that, but I don't think we even have to go back to Tonorama because the legislature adopted 163.
So your argument on appeal is the trial court erred by declaring that the county repealed any customary use rights in 1978.
Yes.
You argue for a remand with further discovery. Can other parties intervene at that point, or where would we be? If we rule in your favor, what happens next?
If the court were to rule in our favor, we would be remanded for additional proceedings, most likely a trial. I don't know if there's anybody left to intervene, frankly, Your Honor. We had, I think, 700 property owners that have intervened over the years that this case has been pending. The case has shifted recently because there's been several settlements and dismissals, so it's been whittled down substantially.
Well, there were approximately 1,200 property owners at issue, according to at least one provision I read in the briefs.
Yes.
Those 500 that didn't get involved, for whatever reason, what's their status if you prevail?
If we prevail on this order or in general?
Let's say we hold that you're correct. We reverse and say, no, the 1978 county ordinance did not abrogate customary use. The trial court says, I find it didn't. I find there's an ancient and continuing use. I find the county can exercise the power to strip property owners of their right to prevent trespass. The 500 people who, property owners, approximately, who didn't intervene, what is their status at that point?
It's irrelevant as it pertains to these 7 parcels and as it pertains to this final judgment. This final judgment is limited to 7 parcels.
Okay,
And
what is the status of the 500 property owners? Can they enforce trespass laws?
They can try if the sheriff will, and
I'm asking you as a matter of law.
as a
Counsel,
matter of law, they
if the 500 property owners did not participate and you prevail all the way down the line, and you have the right to strip these property owners of their ability to prevent trespass on their own property, on these parties, don't the other 500 lose that right too?
well, we would submit, Your Honor, that you're framing the issue differently than we are framing it. They never
Well, that's the
had,
way you framed it in 2017.
they never had the right to exclude. So the fact that they never had the right to exclude, they don't have a right to have a grandmother who's walking on the dry sand arrested for trespass.
You don't have a right to exclude unwanted persons from your property.
Not if the doctrine of customary use.
That's what I'm asking.
can be
So the
proven.
500 people who did not participate have no right to prevent unwanted access to their property.
If we're
If
not
you
there-
prevail, if you
If we
prevail.
prevail, then you're correct.
That's the end game.
Yes.
Okay.
But that's beyond the final judgment. Final judgment is only the 7 property owners that are the subject of Judge Green's order. And I agree, Your Honor, that the county put in play precisely the way the legislature told us to put in play, which was to file a complaint, identify the properties over which the county contended customary use applied through facts, through evidence. We had to identify our factual evidence that supported a customary use determination during the public hearings before the county commission. And the statute states that folks have a right to intervene. It doesn't state, it almost would read out they have the right to intervene if I have an obligation as the county's attorney to name them as a defendant in the first place. But the statutory framework, when we looked at this after our ordinance was invalidated, and we looked at 163.035, and we looked at the framework of folks having a right to intervene, we thought it would be contradictory to name the name of every property owner when the statute called out for people to make a decision on whether to intervene.
What would happen if the county just persisted? I mean, it has left the ordinance on the books. So what would happen if the county just continued on with the ordinance and didn't file an action?
I'm sorry, sir?
And didn't file any of this business with the notice of intent and
Because the
request for an advisory
the
opinion?
county accepted that its ordinance was invalidated by the legislature. And
No,
they
I'm
missed-
asking what, I know you, obviously, that's the position the county took, but what if the county had just persisted and said, we're going to continue enforcing this ordinance?
The county did not believe it had that as an option, Your Honor. The county viewed.
But
that
what if?
It would be a nullity. I don't see how the county could proceed with an ordinance that the legislature invalidated and simply say, legislature, we're going to ignore what you did and continue.
What's the consequence? I guess I like talking in terms of consequences. So what are the consequences for the county in this? Because a lot of this, everything that I've heard today just sounds very academic. Everyone just wants to talk about the academics of customary use, and they want the courts to kind of just weigh in and give our opinion on these things, which is where it seems like everyone treats the courts now. It's just, we just want an answer from the courts. on things, but we decide specific disputes, concrete disputes between two parties based on what the statutes say, what the law says. So in this instance, you have an ordinance that you adopted. You have a statute that, says it's not in effect, but what's the enforcement mechanism for that?
If we were to enforce an ordinance that was invalidated, and this is hypothetical,
Yeah.
Your Honor, we're talking about something that did not happen, I would envision that whomever we enforce that ordinance against would go to circuit court to say the county is precluded from enforcing its 2017 ordinance because the legislature invalidated it. So the property owner X.
And they could also probably assert as a defense that customer use is not a thing, and I have property rights, and you can't force me to accept people on my property, et cetera, et cetera. They could raise a constitutional challenge even, right? Which is the way we used to do things in Florida courts. We'd actually have people sue other people and have disputes that would be resolved by courts.
And in fact, when we adopted the 2017 ordinance, there were, I believe, 7 federal lawsuits that property owners filed challenging the county's ability to impose a customary use ordinance on their property. And we won a home rule argument in federal court while that case was pending is when the legislature adopted 163035 and invalidated our ordinance. So the county still wanted to protect what it viewed as the long-standing tradition of people using the dry sand for recreational purposes that had occurred for generations. So while they were invalidated, their ordinance was invalidated, we said, well, all right, the legislature said we've got to follow this process. So we'll follow this process and we'll follow the criteria that the legislature imposed in 163035, and we'll start again.
And we want advice from a trial court, some sort of determination that, yeah, this is customary use. It's what the county says it is. So that then the county they've got their little hall pass, and then they can go on and adopt this ordinance. How is that not the exercise of executive power, either quasi-judicial or quasi-legislative power that properly is in the hands of the executive branch?
Let me try it this way, Your Honor. And again, I'm going back to after we had just been invalidated. One of the arguments that was raised to support 163035 is that there should be a judicial determination of whether customary use exists, that the legislative body, here the county commission, should not have the ability or the authority to make that judicial determination. So as part of
How is it a judicial determination?
Pardon?
How is that a judicial determination? It sounds like a policy determination.
The judicial determination is whether or not, and the county has the burden under the statute, whether or not the county has presented evidence to fulfill the 4 prongs. And the court determines, after reviewing the evidence, testimony, whatever documentation is provided to the court then makes a judicial determination of whether or not our evidence fulfills the 4-prong criteria set forth in 163035.
Doesn't the customer use doctrine, or if you want to, whatever you want to call it, require a specific property as well, and a specific use on that property that's adverse?
The adversity is a result of a member of the public using dry sand owned by a property owner who believes they have the right to exclude and doesn't want the member of the public walking on their beach.
But that's not every property owner.
No, it's not every property owner.
But you have filed an action, or you've done a notice, and filed call it a complaint, put it in scare quotes, a complaint that asks for determination on all this beach, not a specific property, but all this beach. Because then that's what the statute speaks in terms of. It's just beach, a portion of a beach, not a specific property.
I respectfully disagree.
Excuse me.
Oh, I'm sorry.
No, I'm sorry. I didn't mean it like that. I have a.
I thought you were.
I'm getting it. And you've asked, you said we're going to declare, or we're going to exercise, recognize customer use in all of this beach. And some property owners may have an adverse use of that beach, and some may not. And that was the issue in Tony Roma, is, as a matter of fact, the users of that beach were deemed to be consistent with what he wanted to build on that property. There wasn't an inconsistency or an adversity between the uses. So I don't understand how this whole thing is a proper use of the judicial power to answer a general abstract question of whether there's customary use or prescriptive easement or whatever you want to call it on all of this beach generally, as opposed to specific properties.
Well, I would note, Your Honor, that we did identify every specific property that we were seeking customary use of.
Without any specification of whether there was an adverse use on each particular property. You just named all the properties for purposes of notice, but didn't claim that there was an adverse interest or an adverse use on each property that you needed resolved by a court, which that would be a concrete dispute.
We followed the legislative process that
Right.
the legislature mandated.
And both sides have already conceded or stipulated, I guess, that there's no problem with this statute, that this all makes sense. This is a proper use of judicial power. And we want to move on from there, I guess. And we just want an answer to the question, Your Honor.
We don't view this as an advisory decision because it does affect the property rights of the owners of property identified in the complaint. And there are 1,194 parcels. I'm sure there are some folks that own multiple, so there's probably not 1,194 property owners, but there is an adverse determination with at least some of the folks that are, their properties that are identified in the complaint. I agree with you, sir, that folks that don't object to customary use, then they're not fighting the application of customary use to their property. But I would note, when you have over 500 interveners, and it's not, I know you all are very familiar with Walton County, beachfront property owners typically don't lack resources to litigate. And this has been an incredibly expensive and incredibly hard fought, with parties having differing interests for 5 years.
That's going to happen when a county attempts to declare that every single property owner that owns beachfront property can now be stripped of their rights to exclude trespassers, rather than purchasing property to provide access for their citizens, which that's what's happening here. Whether or not this ordinance is a valid exercise of judicial power, the county has attempted to strip almost 1,200 property owners of their rights to exclude trespassers, and so I am not surprised that it's been a long, hard-fought, expensive battle.
And we frame it
Rather than buying property and providing access to its citizens through a proper use of the Fifth Amendment and providing just compensation.
Understood. But we view it
I know how
that
you
they don't have the right to
I
exclude to
understand
begin.
that.
So they haven't been stripped of anything. It's a affirmation.
They never had that right in the first place, in your opinion.
That's correct.
That's right.
That's correct. And then the last thing I'll touch upon is the failure to allow for discovery. We've raised that. This was a summary judgment. The language in the resolution is different than the language in the notice. The notice refers to interest. The resolution refers to rights. We don't know if this was just the resolution was addressing ownership rights. At a minimum, the petition that was filed for the resolution would have been relevant to determining what is the scope of this resolution. So we respectfully submit that discovery should have been allowed before summary judgment was entered. And we also respectfully submit that the evidence that we submitted to the trial court indicated use of the beach, I believe, since 1930, uninterrupted up until present day. So even if somehow...
If there weren't any interveners, who would you be seeking discovery from?
I'm sorry, sir?
If there were not any interveners, and it was just you in court alone, litigating a case against no one, who would you be seeking discovery against? And would you be filing summary judgment?
Well, if there are no parties involved
Well, there's one.
other than the county.
Just the
other than
county, yeah.
I could still see discovery from third parties that might be relevant to use of the land, whether or not folks bought their property knowing that customary use.
Would you have to
You
give-
could file under this statute, not a single landowner appears to attempt to protect their property rights, but you can take discovery from them anyway, at their expense to find out what? Exactly.
If they never.
They didn't appear, they didn't ask to appear.
Right.
They didn't want to spend the money for lawyers, but you can take their depositions, require them to answer interrogatories, to answer what?
Well, that happens in every lawsuit that you can depose a third party.
I haven't seen it happen in lawsuits without a defendant.
I understand that.
But you said you could take discovery regardless of whether anybody appeared. What would you be seeking with that discovery? From parties that didn't, from people that didn't appear?
Did the current owner or a prior owner ever interfere with the public's right to use the dry sand in question? Did they ever put up a sign? Did they ever tell somebody walking on the dry sand?
But nobody appeared to argue to the contrary.
We still have the burden, though, Your Honor. Under the 163035 framework, we have the burden of meeting.
Well, you come
each
forward,
one.
you present your evidence, you say nobody's ever tried to block anybody from trespassing on their property. Judge, we want a final order in our favor. Nobody's here.
But I don't know what steps somebody may or may not have taken unless I.
But they're not there. They didn't make any argument to the contrary. You win, right?
I don't think I do, Your Honor.
Oh, I see. Okay.
I mean, Judge Green right now has several motions for summary judgment pending against non-intervening beachfront property owners. He has an obligation to review the affidavits, the documents that we submitted in favor of our motions for summary judgment, and he could determine that the time frame of use doesn't rise to ancient, or he could determine that our evidence is insufficient on the following portions of the beach. It's not an empty chair we win. We still have to prove it up to a trial judge.
What happens if, under the statute, let's say, so these 7 appellees, they get, I guess this order says that there's no customer use, I guess, as to their properties. But there's another order that comes out, and as to those 7 property owners, or maybe those 100 beach owners over here, that there is customary use. And their neighbors, there's customary use, or maybe they didn't intervene. So there's customary use, I guess, in an abstentia or something like that. Can you adopt the ordinance? I mean, can you just re-adopt or put into effect the 2017 ordinance?
First, we've got to get a judicial determination that
No, I
we
just
have
said that.
prevailed.
You've gotten the determination. So some, no customary use. So these 7, let's say they win
Yes.
here. So you got these 7, no customer use.
Yes.
Those 7, they get another order, and the judge says, yeah, there is customer use. And then the judge enters another order and says, well, as to everyone that hasn't intervened, there's customary use. And then you got these over here, no customary use. With these orders, can the county then just adopt the 2017 ordinance?
No.
Regarding the ones that
No,
lost.
just the 2017 ordinance, as is, as it's still on the books.
You've complied with the statute, you filed the notice, you didn't prevail against 7, but you prevailed against 1,170, and those 1,170 property owners, for whatever reason, the judge enters order, a judgment against them. Can't you just adopt the 2017 ordinance against them?
And that's why I said no, Your Honor, because the 2017 would have captured all. If we're carving out.
I understand.
That's why I
Counsel,
see-
I'm talking about the ones that don't. I'm talking about you go back to court, you prevail against 1,175 people. Can't you just then adopt the 2017 ordinance as to them and say that people have the right to walk through their property, set up umbrellas, do whatever they will, that Walton County decides they're allowed to do?
Yes, under 163035, that's exactly what the
I
county.
think that's-
Which wasn't my question. My question, I didn't add the as to them. I said the 2017 ordinance as written. Can you just put that into effect because you've gotten a determination of customary use on some beach?
I would submit, Your Honor, that we would have to carve out the parcels that we lost in the subsequent ordinance, because the 2017 captures all.
And that's what the statute says?
Pardon?
And that's what the statute says. It speaks in terms of parcels.
Yes, it does speak.
It says beaches, as to that, as such beach. It doesn't specify. That's-
Thank you, counsel. Would you like to briefly conclude? I know we've eaten up a lot of your time. Go ahead.
I would thank you for your time. We hope that you all reverse Judge Green's decision, remand. And if you do issue an advisory opinion, let it be about the Texas Rangers, please. Thank
Fair
you.
enough. Thank you. I think appellees have some more time.
Thank you, Your Honor. With respect to the statute, and there was, again, some discussion regarding the statute versus the doctrine of customary use as adopted by the Tonorama Court. It was our position earlier, as I said, the statute doesn't create a substantive cause of action or right for customary use. It creates only procedural. But if you were to interpret the statute as creating some kind of substantive codification of the customary use doctrine, and you invalidate the ordinance and it goes away, you're still left with the Tonorama case in 1974 that judicially adopts and creates the customary use doctrine. So it's still there. So if the statute could be thrown to the wayside, we still have a 1974 opinion that says customary use is a judicially created doctrine. That is the heart of the matter. That's why 163 didn't codify and create a statutory cause of action for customary use. It said you can't adopt ordinances and adjudicate property rights because, again, if the statute goes away, what we're going to have is local governments adopting ordinances, declaring customary use has been ancient, uninterrupted, free from dispute, et cetera, on properties. That's going to get on the books. Then the landowners are going to have to file suit against the counties and against that ordinance, saying it is invalid under Fifth Amendment, 14th Amendment, and it's a separation of powers because the legislative body doesn't have the ability to adjudicate property rights, which is exclusive jurisdiction of the court. So that's why it doesn't matter whether you look at the statute or not, the underlying judicial created doctrine has to be dealt with in the 1974 case.
You're not treating it as a doctrine, you're treating it as the law.
The law as adopted by, or purportedly adopted by the Florida Supreme Court.
Sent down by the Supreme Court by edict?
That's correct. If it is substantive law. But again, if it's dicta, it's not substantive law. And that's all I have, unless the panel has
I
any more
don't think there are
questions.
any more questions. Court is in recess.
Thank you.
All rise.